So good afternoon, everyone, and welcome to Enzyme's webinar, the EU AI Act from Articles to Action. My name is Max. I'm a founder's associate here at Enzyme, and I'll be the moderator for this event. We at Enzyme are so glad that you could all join us today for this important and timely discussion on the most important global legislation concerning AI systems. For those that don't know, Enzyme provide an AI governance platform that helps organizations manage and understand the risks that come with AI, whilst also meeting their emerging regulatory obligations. Enzyme was formed in 2021 by a team of leading lawyers and engineers concerned about the risks that computational models could pose to society at large. With this legal background, we know that governance is a vital tool in understanding and managing risk. To get started, I want to first thank our 4 expert speakers for sharing their invaluable insights with us on this webinar. Dan Nichita is Head of Cabinet for MEP Dragos Turodache, who as Rapporteur on the AI Act took a leading role in drafting the legislation. Cornelia Cutterer is a Managing Director at Considerati, Senior Research Fellow at the Multidisciplinary Institute in Artificial Intelligence, and a member of the AI Governance Center Advisory Board at the IAPP. Peter Schildkraut is co-leader of Arnold & Porter's TMT industry team, providing strategic counsel on AI regulation and working with the IAPP on AI governance training. And finally, Ryan Donnelly is one of the founders of Enzyme, a company on a mission to ensure that powerful AI technologies can fulfill their true potential. We'll have some time at the end for audience questions, so please send all your queries through on the chat function to have them answered by our panelists. Thank you all once again for joining us. I'll now open up the discussion on our first topic. So Dan, the first question is to you. Following the positive vote at Coreper on the 2nd of February and the strongly positive endorsement of the Act by the European Parliament's Single Market and Justice Committees this morning, it'd be good to gain an overview of how we got to this point and what the remaining timeline towards implementation looks like.
Well, that's going to be a long answer if we start with the origin of thinking on artificial intelligence, especially in the European Parliament. But I would say that for our office, this was a priority from day one in Parliament. And I recall sitting with Dragos planning our mandate, and we said, okay, AI is the key thing that we're interested in. A few months later, we started working on coordinating the Renew Europe position on AI. This was 2019, and we were the first group to actually launch a position on artificial intelligence regulation. At the time, it was just announced by the president of the commission, but it wasn't there. Then we lobbied for, and Dragos was the chair of a committee that the parliament established to study AI. And I mention all of this because during the committee, for example, and even in the previous exercise, what we did was we worked a lot to educate ourselves as, you know, people working on legislation on what exactly AI is, how does it impact society, what exactly should be, you know, looking for when the legislation comes. So naturally, when the legislation was proposed by the Commission, we already had 2 years or so of experience in the Parliament, and most of the people who were in the special committee on artificial intelligence ended up also working on the file. So I think we hit the ground running. That's why a lot of the proposals in the final compromise are proposals from the Parliament, and then of course you know, the whole complexity of dealing with such a big file in 2 different committees was something that is very rarely done in Parliament. So overall, I would say, you know, it was a lot of work, but I think it's a subject that deserves that kind of scrutiny and that kind of understanding from lawmakers, and that's why we got this positive result in, you know, in Coreper. All the member states eventually agreed that this is a very good compromise text, and in the committees today, the vote in the committees today was also overwhelming in favor of the text. We get feedback from civil society all the way to hardcore industry players saying that this is a good text. It's a good starting point. So, you know, couldn't be more happy of what we've achieved. And as for next steps, now that we had the voting committees today, and it was adopted by committee, the text is undergoing the final checks by the lawyer linguist, and we're probably going to vote in plenary to endorse it for a final endorsement as soon as that work is done. So that could be March or early April, but it's pretty much smooth sailing from now on.
Dan, there was some discussion around that Coreper vote that some countries may in fact have blocked the act. I know it was a nervous period. Talk me through from the inside what actually happened there. Was there some political wrangling? What actually happened in the end?
Well, look, I think it's pretty normal for, if you think about the technology itself and the massive benefits it can bring to society, for everybody to be super careful when working. And that's why I started by saying, we have a very good text. So I think it was absolutely natural that member states want to take their time and to look over the text to make sure that, Europe stays competitive, because the whole idea of the AI Act is to make the European Union more competitive. It's counterintuitive, right? Because everybody will say, well, yeah, but there are compliance costs. But there is a logic here. So the logic is, there are AI systems that pose some risks to, health, safety, and fundamental rights. Once you tackle those risks, and you have AI systems that are basically safer on the union market, then you have more trust in the technology. You have more trust, then you have more adoption of technology at the societal level, right? So in a sense, it does facilitate, AI adoption. But I can understand how member states really wanted to take, their time to look over the text to understand, is this going to actually help and achieve its goal? And I think, again, the unanimous vote in Coreper showed that no matter what doubts there were about different parts of the text, I think in the end it proved to be, everybody said this is a good solution.
Awesome, thank you. So just to change tack slightly here, one of the most important aspects of the Act is the implementation of risk categories for AI systems. Cornelia, could you please explain how the Act seeks to categorize AI risk and the methodology given for organizations to correctly classify their AI?
Yes, sure. And thank you, first of all, for the invitation, and also big kudos to Dan and his whole team, which has been incredible to work with for a number of years on this file. So basically, from the start, the proposal of the European Commission had a structure that has not fundamentally changed, even so the text has undergone significant changes from back when it was first proposed. So the pyramid that many have seen remains the same, with a slight introduction of a new risk category. Largely, we have the unacceptable risks, so systems in that space are prohibited. I'll go back to that in a second. High-risk systems, this is the large chunk of the regulation that have to undergo significant obligations in order to be able to be marketed and deployed in the European Union. Another category that is extended now a little bit is those that have transparency obligations. These are in particular systems that interact with natural persons, as well as those that generate artificially content, voice, speech, etc. And then, of course, there is a big chunk of technology that's unregulated under the AI Act. And I would like to eventually point out that even today, the Commission expects that the high risk, which is this big chunk of regulation, is only certain percentage of all the applications, which when you think about the annexes in which those categories are further described, is normal. So at the beginning of the AI Act discussion, in the impact assessment of the Commission, it was estimated that the high-risk scenarios is 5 to not more than 20% of all use cases. And that was way long before large language models sort of have taken every angle of society in storm. So maybe even now that is a little bit less, but it has repercussions in how we need to think about risk assessments. So I think for anybody that builds models, provides AI systems or deploys AI systems, it's really, really important to categorize AI systems and document the intended use in order to understand in which category of risks they fall. So in the AI Act, you have basically 2 annexes in which the high-risk use cases are described. These are those if an AI system is embedded in a product that falls under the safety regulatory framework of the European Union, or it is specifically listed in Annex 3, and these are sort of remote biometric identification, critical infrastructure, education, employment, law enforcement, migration, and justice. So these are like the very broad, rough cases, and they are of course slightly more specific. It also should say, even if your AI system is intended to have a use scenario in those categories, that might not necessarily need that you fall in a high risk category. There might still be, and that is a important, I think, way for here. It could still be exempted from deploying all these obligations. For example, if in these spaces it is only used for procedural tasks to improve a human assessment, to detect decision patterns without being a decision, or if it's only a preparatory task. So there is a lot of limitations to that risk category. Then for the models, they have to follow, so model providers are now obliged to follow specific transparency obligations. They are broadly also referenced in an annex, but will be further developed in a code of conduct or in a standard. And I mentioned at the very beginning that there is a new category. It's not specifically expressly mentioned like that, but I think it is a new risk category, which is the systemic risk. So general purpose AI models that have a certain high impact might be considered systemic. There is a lot of different ways in order to be designated by the European Commission or by the AI office to be systemic. And those models then have to undergo certain risk mitigations in addition to the transparency, obligations of all general purpose AI model. That's sort of like the rough, very high level introduction to the risk systems of the European AI Act.
That was really great. Thank you. So kind of following on from that, Peter, given your experience working directly with organizations on AI regulation, how often do you think organization systems will fall into these categories? I know it's already been spoken about a bit, but it'd be great to get your view. And then following on from that, how large do you think the regulatory burden created by this will be?
Sure. Thank you, Max, and thank you, Ryan and Enzai, for having me, and for including folks from my side of the Atlantic Ocean. Greetings to everybody from Washington, D.C. So to Cornelia mentioned the perspective of the percentage of high-risk applications from the outset of the AI Act's drafting. To put another bookend on that, a Silicon Valley in-house counsel I know has said that the AI Act treats as high risk everything anyone would want to actually do with AI. Now, I think that's actually exaggerated, but it's clearly going to have a significant impact on a lot of different companies and organizations. But it's going to depend in particular, and as a lawyer, I've got to use the word "it depends" or phrase "it depends," but it will depend on the nature of the AI system in question and how the organization intends to use or market it. So organizations that are in or selling into sectors where the use cases tend to be high risk or even prohibited are much more likely to have systems in those two categories than other sectors. So for example, if you're in financial services and are allocating credit or undertaking insurance underwriting, or you're engaged in surveillance and security systems and services, or mechanical or transportation safety systems, healthcare, et cetera. If you're in one of those sectors, then yes, it's going to be a much more heavier impact than if you're in a sector where the use cases are much less likely to be high risk. But even in outside of the sectors with where one would expect to find the high risk use cases, that every organization is an employer, and every organization therefore has to pay attention to human resources applications, which are high risk. So what does that mean that organizations ought to be doing? They ought to be inventorying their systems, as Cornelia mentioned, assessing risks and mitigations generally, and then also assessing the risk classifications under the AI Act as they scope out their compliance tasks.
Great, thank you for that. So that kind of concludes the first section on risk classification. And so we'll now move on to our second, which is on key requirements of the Act. This next question is to you, Ryan. A crucial part of the Act is the need for organizations with high-risk systems to create a quality management system. Could you break down what this involves and how to put one in place?
Sure can. Thank you very much, Max. So just before I do that, if I take a quick step back and think about this, those were great comments on what constitutes a high-risk system under the Act. And I think sometimes when people hear that their system may be high risk and may come with compliance obligations, there can be a tendency to run in fear and think, oh my goodness, these compliance obligations, the lawyers are coming for me. I want to present a slightly different view than that potentially, which is if you look at what some of these compliance obligations are, I think they make just general common sense and they're actually really helpful. So I would actually really thank the European Union for forcing the conversation around a lot of this. I think it has, the introduction of the Act since the first draft has really sparked a conversation around standards in this space and how organizations should be holding themselves to standards throughout the life cycle as they build, deploy, and use these kind of very powerful technologies. So under the Act, one of the requirements is to put a quality management system in place. The overall purpose of a quality management system is obviously to ensure that your AI systems are high quality when they're built, deployed, and used in the on the common market. That makes a bunch of sense. Like if you look at the text of the Acts here, it asks for things like put a strategy in place for regulatory compliance, put in place quality control and quality assurance procedures, make sure that you have efficient systems around data mapping and management, make sure that you have a post-monitoring market systems for these. Basically set your organization up for success in this field by making sure that everything you do is really, really high quality. Now, we do that across all other aspects of our lives. Like we generally trust how food makes its way from the farm to our plate, and because it follows a quality management process. And I just think the introduction of this into artificial intelligence is going to be a net positive gain. And to Dan's point at the beginning, regulation can actually be really, really helpful in ensuring technologies fulfill their true potential by putting in place the right standards and the right rules. So Parts of that quality management system ensure that you do things to a very high standard. It also asks for a risk management system in respective individual systems. So putting in place a risk management system to identify and track risks in respective individual AI systems that you might identify, making sure that you're able to mitigate those, put mitigation strategies in place to ensure that those risks, if they can't be totally mitigated, can at least be managed in reality. And I just think that's going to be like incredibly important going forward. Like this should be something every organization should be looking to do, regardless of whether or not a specific AI system is high risk or not. I think it can be your competitive advantage almost as an organization to ensure that you're holding yourself to these really high standards. Just to touch on some of the other obligations very briefly under the Act, there will be an obligation to register high-risk AI systems within a European database. I know work is being done to put that in place. There will also, I'm quite excited to see this, the traditional sort of CE mark that you see on lots of different products here in the European Union. We're in the UK, so we don't actually see those marks as much anymore, but I do miss them. I think that will be a really cool addition to see that in the digital age. So I'm very much looking forward to that as well. But yes, to round off the comments, very much think that quality management systems and risk management systems are a bit of a no-brainer in this space when the technology is this powerful and dangerous.
Great, thank you very much. So kind of moving on from that to a slightly different tack on enforcement. Importantly, the Act provides for the creation of a European AI Office, AI Board, and the designation of national competent authorities by the member states. Dan, I know that your office was very involved in the kind of genesis of the AI Office. So it'd be great if you could please talk a bit about the role that these bodies are intended to have and kind of how you foresee organizations interacting with them.
Definitely, but I want to stick one, second to points previously made because in our group we are very familiar with the Act, so we're touching on different aspects. But for those listening who are just a company trying to understand the AI Act, there's a big distinction to be made here between what we call in the Act providers and deployers. So the providers are those who build the systems, those who build the AI. And most of the obligations that we have in the AI Act go with the providers. The deployers, those who use it. So if you're a small company just using AI in your company, have little to none obligations depending on whether it has an impact on fundamental rights. There's a big distinction, right? So most of the obligations, including the risk management system, rests mostly with the providers of AI systems. So that distinction, I think, is very important for especially for startups and for smaller companies who are looking at it and saying, "Oh my God, no, what is this?" So with that being aside, I'll go back to your question. And I think that the logic is, the logic of the European Union. So the member states are in charge of transposing regulation and in ensuring its implementation at the national level. So everything in the original text that was proposed, and Cornelia really captured the whole logic of the pyramid of risk, will be everything that was proposed as high risk will be monitored and enforced by the authorities of the member states. So that's part number one. The board is the place where these member states come together and they share, their experience, they share good practices, and they talk about the implementation. Then the AI Office is the European level enforcer in a sense. Now it's also lodged in the Commission, so it has with it the enforcement power of the European Commission. And the AI Office deals with the new addition that also Cornelia very well presented of the AI models, and in particular the AI models with a systemic risk. That is the very, very powerful AI out there that can have impacts on our societies, on our economies. And that structure has multiple roles in relation, in particular, to these models. So the first role is really to understand the market and to keep updating the thresholds and the classification of the models with systemic risk, because technology evolves, and what is now potentially a model with systemic risk, it could get better over time, and then in a few years, it's not going to be a systemic risk model anymore. Or new models might be built that present capabilities that really have an impact on the whole European market. But that is a co-creative effort. So that is, the office has the task to work with industry, and that's where the codes of practice come in, to work with industry to actually define, how exactly are you going to implement the requirements in the regulation, to understand the market and not to, regulate top down, but actually co-regulate with the industry exactly how these, requirements, again, for the very high level powerful systems are going to play out. Then another important part, and it's encouraging that we have somebody from the other side of the Atlantic. The other important part is this office is tasked with international cooperation, right? There's efforts in the United States. The White House has worked on that executive order, which is quite comprehensive for an executive order, and they have just established an AI office in NIST, AI safety office in NIST. It's given a lot of political attention. So another task of the EU AI office will be to work with these offices and likewise in other jurisdictions to coordinate on this. And then finally, I think its task is to learn from the market and to suggest changes to the regulation later on and to keep up with new developments. So it's got that element of both regulatory flexibility on one hand, but also future proofness, that is, making sure that the regulation works in the future as well. So to sum it up, national competent authorities will be dealing with monitoring what is really strict in the law, that is the high-risk AI systems, and ensuring compliance of those systems. Then the board is where these national competent or supervisory authorities meet and discuss and coordinate. And then the office deals with the models, the powerful models that have an impact on the European market. And again, I mentioned what its role is. So that's the broad lines, the governance structure. I would add one element to it, which was not in the prompt, but I feel is important. What we have foreseen in the AI Act alongside this governance structure is also a structure of sandboxes, regulatory sandboxes where companies can go and work with the regulator to get compliant with the AI Act. So if you're building a high-risk AI system, you can go to one of these sandboxes, which we Parliament have asked every member state to have one. You can go to one of these sandboxes and you can work with the regulator without being punished and learn how to become compliant. So this is very useful for startups and for companies that are trying to innovate and they don't have the resources. So we feel that's also part of the big governance picture in a sense, but more innovation focused.
Great. Thank you very much for that overview, and especially the mention of sandboxes, which was super interesting. Kind of following on from this, as you alluded to, many of the key requirements of the Act take effect in 2 years' time. Peter, could you tell us when and how businesses, especially non-European and American ones, should start preparing for compliance? And also, does this involve the sandboxes? And do you think the timeline will be affected by the potential financial penalties for non-compliance that are mentioned in the Act?
Sure. So there are at least 3 parts to your question, Max. So who needs to comply? When do they need to get started? And how important are the penalties? So perhaps to state the obvious, EU-based providers and deployers, and thank you, Dan, for interjecting with your thought about the key distinction between providers and deployers. But so both in the EU have to comply. And so will many non-EU providers and deployers. That's because the AI Act has extraterritorial application, and it captures providers and deployers of AI systems, regardless of their location, If the provider is looking to sell its system into the EU, or the deployer is looking or will have be producing output that is intended to be used in the EU. So as to when people ought to be complying, I would strongly encourage companies not to be waiting and trying to scramble at the last minute to come into compliance, as occurred with the GDPR, as many will remember. This is probably going to be a more complicated endeavor than GDPR compliance was, and may well take the full runway that we've got until the act starts to come into force. For non-EU companies, even if you think that the AI Act doesn't apply to you now, you may be cutting off opportunities to scale and to market into the EU in the future if you're not thinking about compliance at this point. In particular, providers of AI systems, developers, if it's a high-risk system that may be introduced into the EU market after the relevant effective date, you're going to have developed your model and system in compliance with the risk management requirements, with quality management requirements, and the other requirements of the Act. And if you're not paying attention to these requirements now, the systems that you're developing may not be compliant, and you may not be allowed to put them into the EU market until you have redeveloped the systems in compliance. And that may mean starting from scratch, which is not something that a business is going to want to do. For deployers of high-risk AI systems that are outside the EU, but may be providing output into the EU, the key obligation is going to be using systems that are certified as compliant. That they obviously don't exist yet, but that's something that you're going to start needing to think about as you are contracting for AI systems in the future. And then you're going to have in place processes to ensure compliance with the deployer's obligations under Articles 29 and 29A. So that means a deployer is going to have technical and organizational measures in place to ensure that use of the system is in accordance with the provider's instructions. So you can't be using it off-label. And you're going to need human oversight by people with the necessary competence, training, and authority and support in order to operate the systems. And having the necessary training and other elements of competence and authority is going to take time. So you're going to need to be building in HR and career development planning and programming so into your regime, and there's going to be a bit of a time lag in order to figure out what the scope of your obligations will be, and that figuring out whether or not your use case is going to be high risk or not. And so deployers are going to need to build in that time, the assessment time, about whether or not they're going to be using high risk use cases in order to figure out, or as they need to build in that time before they actually get started, and they're then going to have 2 years to implement. So it's time for folks to get started. And even if you're not sure whether or not you're going to be covered under the AI Act, you ought to be managing your risks now. There are ways to manage AI risks that NIST, which was mentioned earlier by Dan, very helpfully came out with the risk management framework and playbook, which are law and jurisdiction agnostic. The International Standards Organization has a couple of standards, ISO 81-2030 on AI management systems, and 77304, AI guidance on risk management, that can help organizations figure out how to manage the risks. And it's important to manage the risk whether or not you're going to be subject to the AI Act for a variety of reasons. That there's reputational harm that you can be encountering if your AI goes wrong, that there are issues in litigation, for example, customer to provider. Well, I don't want to use provider in the technical sense, but customer to company, as well as business to business, for problems with the AI systems being inaccurate, not performing as expected. There can be shareholder litigation if you're a public company, if you're saying that your AI is going to be not presenting risks and it turns out that things go wrong, as well as government agency risks on this side of the pond, as well as elsewhere around the world. Finally, turning into to penalties, obviously the penalties in the Act are an important consideration and deterrent, but I don't actually think that they're going to be the dominant motive here. That most companies want to comply with the law to be good corporate citizens. And as I mentioned, that they fear bad public relations and other liabilities from things going wrong. As I mentioned, various different types of litigation that can ensue, at least in the United States, and I believe in Europe as well. So, and then finally, you want to be able to say, to use compliance proactively, saying that you are compliant with the AI Act can be a good marketing tool, even here, where it may not matter whether or not you're, legally speaking, that you're compliant. It may well, for the reasons that I mentioned, but even if it doesn't, at least it's a stamp of approval from that you have met the requirements of a significant piece of legislation. So, hope that was
Definitely.
a rather long answer to a deceptively simple question.
No, that was great. Thank you. Very clear. And kind of, you mentioned somewhere in that GDPR, which I think leads quite nicely onto our next question and the last in this section, which is to Cornelia. Could you please tell us a bit about the requirements under the Act for deployers of AI system to complete FRIAs, and how this will affect both their DPIA work and the overall hygiene of the kind of governance ecosystem here?
Yeah, there is, thanks for this question. There is a really, really interesting interplay between the General Data Protection Regulation and the AI Act, obviously in the context of data governance under the obligations. And before I go into the FRIA and DPIA and how I think this will evolve, maybe just to add one addition to what Peter eloquently described, the fact that there is model transparency now coming into force through the new obligations that will, I think, insert some hygiene in the AI ecosystem that will also have an impact on due diligence in the context of tort law. So as companies that deploy AI, whether it's high risk or not, they will be measured by how diligent they do and what sort of the state of the art of that type of diligence will be. So I would imagine that in a couple of years, we might see non-high risk situations where harm has been created, and I think companies will have to sort of think about these type of risks as well. So this hygiene will, I think, go way beyond just high risk systems, and hence I totally subscribe to what Ryan was saying and what Peter is saying, that this is actually a broader governance, responsible governance question that we are looking at. And then to the question around FRIA. So through the European Parliament, a new obligation has been added for the deployers to undertake a fundamental rights impact assessment when they deploy high-risk AI systems. And a little bit of an opinion here, I think that was really absolutely important, because generally the obligations of deployers has not been the focus of the AI Act per se, but much of harm is very contextual in relation to specific deployments. So the Parliament rightly, in my belief, has refocused attention a little bit on the deployer side. Now, as it happens, many of the deployers will deal with personal data, and since it is new technology under the general data protection obligations, they in principle have to already do data protection impact assessments when deploying new emerging technologies. And so there is even if you do not have the obligations to undertake a fundamental rights impact assessment, which is now in the trialogue reduced only to public sector use cases, so deployers that are public administrations or respectively private sector that deploy these systems in the context of obligations related to public sector. So then you have to undertake a fundamental rights impact assessment broadly looking at potential risks in relation to impacted persons. Now, there is, as I said, for those that already do data protection impact assessments, there is a bit of an overlap, and this will be integrated. Often you can think of the AI system provider potentially be the processor of data as well, while the deployer might be the data controller. So these data protection impact assessments will, in my mind at least, become much more significant as that what we have seen so far. So I'm not sure whether the practice of data protection impact assessments has been the focus in the context of complying with general data protection obligations. And it has certainly not been the focus on enforcement on GDPR from data protection authorities. But I think with the AI Act, data protection impact assessments, generally for all those that deploy high-risk AI systems, will become a significant tool in their overall compliance thinking. So that for those who support clients like my organization or ENSI here or Peter's organization, we all, I think, will have more work to do in the context of data protection impact assessments, in addition to fundamental rights impact assessments. So the broader, more generally, data protection impact assessments, and specifically for the public sector, additionally, fundamental rights impact assessments.
Great, thank you very much. We're going to pivot here slightly to the global impact of the Act. So one of the wider aims of the AI Act is to set a global regulatory standard for AI, much like how GDPR did for privacy regulation. So Dan, perhaps you could please share how the EU considered this aspect in drafting and what it hopes to achieve, really, this kind of Brussels effect.
Definitely. And I think that, I wouldn't want to phrase this as a Eurocentric perspective in a sense. That is, the Brussels effect is kind of, it starts from Brussels and then it goes global. It is, a term coined to say that the European Union has this regulatory power, which indeed it does. But I think that the way I would like to phrase it is more in terms of interoperability and in terms of potential convergence in some cases. That is, throughout the process, we have a lot. You have to really look carefully through the text to see exactly those things that happen behind the text. But throughout the whole process, we have worked and engaged with basically everybody working on similar initiatives. So with the United States, we have worked and coordinated and discussed continuously on what exactly this will look like. And to a certain extent, I feel that although in two different regulatory traditions, our conversations have influenced the outcomes on both sides of the Atlantic. And I think that there are similarities between multiple such initiatives. In the text, we have provisions that point to the need for further convergence or cooperation. One example that I would give, which was again, not visible in the text unless you know how to look for it, it's the work that we've done with the OECD to align on the definition of AI. So the OECD has initially proposed one definition way ahead of the European Union. Then the Commission who proposed the original draft legislation proposed a totally different definition. And a lot of work done by Parliament was to work with the OECD to get to as close of a definition as possible in both cases. And that's a success that I feel we had, because now they look very, very similar. And in the US, again, in the executive order, in NIST, the definition seem to be converging, and that goes into standards and taxonomy and so on. But we share a common vocabulary on what exactly it is that we're talking about. Now, in terms of and so that was a lot of work that we've done so far on coordinating. I think that the Brussels effect, because you prompted me specifically on the Brussels effect, will not work exactly like the GDPR, because in a sense, the AI Act is a more complex piece of legislation, because when you think about AI, it's a little harder to pinpoint all of the needs and all of the requirements and the obligations, especially as I mentioned before, in the more powerful models, as is with personal data. Personal data, you have a definition, you understand what it is, and then you can enforce the rules. So I think that there's a lot of international coordination that still needs to happen, where I'm sure that the EU will deploy also its foreign policy and diplomacy and participation in all these international coordination bodies. But I do think that this effect is already felt in a sense. And is it because of the union's regulatory might, or is it because it really makes sense that you would focus on the risks and leave, the market that doesn't pose any risks, rather free? The approach that we took, I think, makes sense, and there's only so many ways in which you can think about data that you put into an AI system. There's only so many ways in which you can think about risk management. There's only so many ways in which you can think about some of the requirements that we have in the law. So I think there is a natural plus for that Brussels effect, which is a lot of the things in the AI Act, like Peter mentioned earlier, for example, make sense, and Ryan also mentioned it. They make sense, and it's good for them to do, to have them done if you want your company to be competitive. There is a minus to that Brussels effect, in that it is more complex, so it's going to require also diplomacy and participation in these international fora. But I do think that it does set, a standard, an example. It's going to be perfected in the interaction with others, but I am confident that it's, it's going to have, again, not a Brussels effect, but that there's going to be convergence, and if not convergence, because that's a powerful term, at least regulatory interoperability, following the same objectives through different means. So, I don't want to promote it, but I would also say that, getting compliant with the AI Act will probably get you compliant in other regulatory environments as well.
Great. Thank you very much for that perspective. So we've spoken a lot about the AI Act from kind of a theoretical viewpoint, but we'd like to touch, as we get close to the hour, on the more practical side now. Ryan, could you please share your kind of top actionable tips and best practices for large organizations seeking compliance with the Act?
I sure can. Thank you very much, Max. And listen, I appreciate that sometimes if you're an organization here, if you're a chief privacy officer sitting hearing all this information, it can potentially feel pretty overwhelming with the 101 other things that are already on your plate at the moment. All of these additional complicated laws that you think are coming from Brussels, but you're sitting in the US, so don't affect you, but now you're hearing they might affect you. I get it. Fear not. I will offer a couple of practical tips I think that will really help. So first of all, I think this can be organic, right? So you can put AI governance and compliance in place organically. If you start now, there is time to grow experience in this field as we move towards full implementation. You can understand what you should be looking at, what do the risks look like. You can build up a bit of expertise in this area to be able to do it effectively. I will also say it can be proportionate to the size of your organization. So if you are a smaller organization, I don't think there will necessarily be a need to go and establish all kinds of AI review boards and all kinds of reporting structures and put in place lots of operations and things like that. I think you can put a program in place and a quality management system, a risk management system that is proportionate to the size of your organization. And I think if you really want to look at how you get started in that, it's been touched on already in some of the responses, but just to consolidate and summarize it, we have at Enzi what we call the start fast method, and we call it 3 steps that you can take today towards getting on that journey of compliance. The first is just gathering that inventory of all of your AI, figuring out what AI you're building, how you're using it, what does that all look like, pull it into one place so that you know what you're working with. The second then is to look at the policies and the frameworks and look at the requirements of the EU AI Act and start to try and apply these requirements, the requirements of a quality management system to what you're doing already. Start to try and apply a risk management system, look at the risks that you're trying to identify, track them, try and mitigate them. I would advise organizations to look towards some standards in this space as well. So there's been some really, really good published. And I'm thinking particularly of some of the ISO ones that Peter mentioned, and I'm thinking also of the NIST AI risk management framework and many, many others for different domains. The Alan Turing Institute in the UK has an incredible resource called the AI Standards Hub, which consolidates a lot of these standards in one place. Look towards putting those standards in place. And then once you've done that, you can start then running those assessments of individual AI systems from the inventory against those requirements and those standards. And I think if you start to do that, you'll be well on your way to compliance. And ultimately, you'll be well on your way to actually just building better systems. Like it will result in better, more reliable AI. So it's kind of a no-brainer to get started on this now. We also, shameless plug, we also have a couple of free resources that might be helpful on this as well. We've prepared a guide on drafting AI policy. Reach out to the website. Happy to share that with anyone. We've got a couple of infographics as well, which might be able to help. So rounding it off, I can see, I'm going to jump slightly ahead here because I can see a question in the chat here that's just teed up for me. And it's, what do you think of AI governance SaaS companies? I will be honest, I do quite like them. I did find one. But yes, I think practical tips, you can get doing this today. I think there's no time to delay and you'll really benefit from doing it. So thank you very much, Max.
Awesome. Thank you, Ryan. So we did want to leave some time for audience questions at the end. We only have a couple minutes, but hopefully we can get through 1 or 2. So I'll just ask that you guys keep the answers as brief as possible. So I think the first one that I see here is, does quality assurance and management in the context of governance fall under general ML ops, or should it be somewhere else? Does anybody want to take that question?
Yeah, so it's a great question. So the infrastructure is critical, obviously, to delivering these kind of AI systems. You have to have good infrastructure in place from a technical perspective to make sure that you're delivering these. I would say ML ops is super important, but it's also just one piece of the puzzle. I always say how AI governance is a bit of a team sport, and it involves lots of different stakeholders from lots of different areas of expertise all coming together to make sure that they're making the right decisions about these kind of systems. Infrastructure is one, but also compliance is another. Business use case is another really important point. It takes a village on this stuff. ML ops is one critical part of that village.
Great, thank you. And then I see one here that says, do you think that AI safety and responsibility, and I guess we can include governance here, will become commercially valued? So I know, Peter, you spoke briefly about this in one of your responses, but it'd be great to kind of get like a specific response from this from you.
No, absolutely. I think that being able to say that you're compliant with something, and an ISO standard, the AI Act, risk management framework, I think will be a marketing advantage because there are lots and lots and lots of AI products out there, and companies are going to be looking for a way to sort through them as they're sourcing their inputs from the potential suppliers. And so I really do think that there will be a commercial value to risk management affirmatively, and not just being a cost center.
Great, thank you. I think we have time probably just for one more quick one, which I see here is on sandboxes, and ask some practical questions. Perhaps Dan, I don't know whether this information is public yet, and if it's not, then I guess there's no answer, but is there any information on how sandboxes should be accessed by enterprises?
Well, not really, because part of the work that we've done on the sandboxes is also to mandate the Commission to issue specific guidelines on how they should function. So we didn't want to put them into hard law. We wanted to make them more flexible because these will need probably adaptation. What it is for sure is that there's going to be more public information soon. So as soon as the Commission starts working on the implementation of the AI Act, and if you're in a specific member state, it wouldn't hurt to see when the member state designates the National Supervisory Authority, and to get in touch with the National Supervisory Authority to ask them about the plan on the sandboxes. I know some member states have already started on their sandboxes, and all of these mandatory sandboxes will be made public as soon as they are established on a Commission website. So there's going to be more information. But of course, because the Act is not into force yet, and there's going to be a time lag between now when we vote on it and the moment of establishment, unless some member states already have them. And I know a couple of member states have, really pushed on having an AI sandbox. So it's coming soon. The answer in a few words.
To jump in on that very quickly, I
think. Sorry,
Max, I was just going to say very quickly that if you check with the DPA, the Data Protection Authority in various member states, I think you'll find that at least a couple already have sandboxes up and running, although not specifically with respect to the AI Act, because they don't know what they're targeting yet.
Good. Thank you for jumping in with that. That was really helpful. So I think that concludes our very insightful discussion on the EU AI Act and what it means for your organization in terms of the implementation. I want to sincerely thank all our panelists, Cornelia, Peter, Dan, and Ryan, for sharing your expertise today and for this great discussion. Thank you all, everyone, and we'll now close the live stream.
Thanks very much. Kudos to you, Max,
you.
as well, for moderating. Thank you.